So to continue our conversation around the different systems and the types of resources that are available to survivors of domestic violence, we're going to move from the civil system and we're going to now talk about the criminal system. And while we're going to talk about them as two separate systems, they're often working in line with one another. So very often there's a criminal case that corresponds to a civil protective order petition being filed. So they're two separate systems, but often they do overlap in terms of the time periods that survivors are accessing these systems. So the learning objectives for this portion include understanding the criminal process for domestic violence reports, being able to identify the difference between criminal and civil stay-away orders, and understanding the documents that are required for someone to access crime victims' compensation. So the first thing we're going to do is get a quick introduction to the agencies that are involved in criminal cases. The first is the Metropolitan Police Department, or MPD. This is the district's police department. They do everything from take initial reports, make arrests. They have detectives that conduct investigations. They can also be safety escorts for clients, either getting their things out of the home of their abuser or as the abuser stands by to get their things out of the home of the survivor that we're working with. And they also serve temporary and civil protection order paperwork. The next is the U.S. Attorney's Office. They are a federal agency. D.C. is not a state, so we do not have a state's attorney's office. So crimes in the district fall under the jurisdiction of the U.S. Attorney's Office. So they are the representative of the government in criminal cases, and they prosecute defendants for crimes. The next is CSOSA, or Court Supervised Offender Services Agency. Again, that's our probation or parole office in D.C. And then finally is the Pretrial Services Agency. They are the agency that they make the recommendations when someone has been locked up for a crime. They make the recommendations in terms of their release status. What should the requirements be for that person to be released back out to the community? They also supervise the defendants after arraignment until the case has been completed, whatever that looks like for that particular case. Judges, they oversee criminal cases. Depending on the case, they might be the ones making the determination about culpability for crimes and sentencing. For other cases, juries are the ones that decide culpability. Unlike the civil system where you're not guaranteed an attorney, in the criminal system, the person who is charged with a crime is guaranteed an attorney, and often these are defense attorneys that the state provides, or they can hire their own separate attorney. The D.C. jail, that's where prisoners are held before trial, and they also do shorter jail sentences at the D.C. jail. If someone has a longer sentence that they need to serve, the Bureau of Prisons is going to be where they stay for the duration of their time while in lockup. There is not a Bureau of Prisons prison in the district, so when someone in D.C. is getting locked up for a longer period of time, they're going to be sent to a different state for the length of their sentence. The Office of the Attorney General, they play two separate functions for domestic violence survivors in D.C. So the first is that they can represent petitioners in that initial CPO case. So they can act as the petitioner's attorney for that protection order. They also act as the government with violations of protection orders. So the U.S. Attorney's Office is often doing criminal cases where the police have been involved. The Office of the Attorney General can prosecute cases of violations of protection orders. They also do a lot of child abuse and neglect cases as well. There are a ton of other police agencies in D.C. There's Housing Police, there's Metro Police, Park Police. They all have different jurisdictions. The agency we work most frequently with is the Metropolitan Police Department, but occasionally we do have these other agencies call us and refer people to our services. And then finally, there are other criminal justice agencies in other jurisdictions, particularly Maryland and Virginia, where someone might be going through the civil process in D.C., but they might have a criminal case that's pending in another state. So one thing to note is that if someone is interested in making a police report, they should not call the station. They should either call 911 or they can go into the police district. If they call the station should be directing them to do one of those two things. but they cannot take a report over the phone. So they either need to call MPD to come out to where they are, or they need to go into one of the districts to make a police report. So types of crimes that we frequently see that are domestic violence related. The first is different types of physical assault. So this can be with or without visible marks. This could be something that is disclosed or something that the police officer, based on other evidence, is able to gather has happened. There doesn't have to be any witness. The most typical type of report that we see is a simple assault. So we often see that written out as SADV. It's simple assault domestic violence. That's a misdemeanor case. We can also see aggravated assault or assault with intent to kill. Those can be felony level crimes. So a misdemeanor crime has a lesser punishment, and then felony level crimes have a higher level of punishment. Weapons charges. So we often get reports for ADWs or assault with deadly weapons. This can be any type of weapon. The most frequently seen ones are knives or guns, but this can be anything that's used as a weapon. So a chair, a skateboard, a lamp, whatever was used as a weapon in an assault. There can also be possession of a prohibited weapon. So if someone is not supposed to have a firearm and they have a firearm, or in DC, tasers are supposed to be registered with the district. If they have a taser that has not been registered, that could be possession of a prohibited weapon. Different types of threat reports. So there doesn't actually have to be any physical violence. There can be threats of bodily harm or threats to kill. Those are different types of police reports as well. Stalking or harassment, it depends on a lot of different things, but it can be a misdemeanor or a felony if that stalking or harassment has crossed state lines. Violations of protection orders are generally misdemeanors, but again, if it's it can be a felony if it's crossed state lines. And then destruction of property as well. So these are those common types of reports that we see. So again, a misdemeanor is an offense that's not indictable and it carries a jail time of less than 1 year. A felony, they're more serious offenses, they are indictable, and it carries a jail time of 1 year or more, or in theory, the death penalty. So when an officer goes to the scene of a crime, what they are looking for is probable cause. There needs to be probable cause that a crime has occurred. And you see the dictionary definition is the existence of circumstances that would lead a reasonable and prudent person to believe in the guilt of a person. So this is the definition that officers are using when they go to a scene, when they are making determinations as to whether or not they believe a crime has been committed. And so for MPD, in their general order, so MPD's general orders, those are the guidelines that guide how they are supposed to respond to different incidences. So these are the things that they should be taking into account when determining probable cause. They should be looking at the existence and the nature and the extent of the injuries of the parties. Any pain from non-visible injuries, they should be taking that into consideration. The need for medical treatment, the presence or use of weapons, evidence of torn clothing, threats made in the officer's presence or a third party's presence. So if a neighbor overheard something or someone else that was in the residence witnessed something, they're going to be taking that into consideration. The demeanor of the parties when they go to the scene, they should be examining that. And we're going to have a sergeant come in next week and talk more about their process. They should also look into the existence of temporary or civil protection orders or other types of protection that have been established in the past. So MPD, their system that they can look things up in is called WALES. They can see civil protection orders, but they may call us on the response line to check to see if there is a temporary protection order in place, because that is not something that they can upload into their WALES system. But they should be looking at that as a consideration. Prior history of domestic violence calls, and then any prior TPOs or CPOs. In DC, we have what's called a mandatory arrest law, meaning that if the officer finds probable cause, they must arrest somebody. And this is regardless of financial or employment consequences, whether or not the victim in the case is cooperating with the case, or if they have reported prior complaints. The marital status, sexual orientation, or age of the participants, the claims that the victim provoked violence, Speculation that the victim may not proceed with prosecution, that's a big one. So even if they don't believe that the person who is the victim of the crime is going to assist with the prosecution, they still should be making an arrest, even if they do not believe that person is going to assist them with the case. They should not, they should still make the arrest regardless of whose name is on the lease, the title, or the deed, and evidence that the suspect or the victim has been abusing drugs or alcohol. So all of those things, the arrest still has to happen. So even if the victim doesn't want the suspect arrested, if the police find probable cause that a crime has been committed, they have to arrest the person who they believe committed the crime. So again, mandatory arrest, they are required to arrest a person if there's probable cause to believe the person committed the interfamily offense. You can see if it resulted in physical injury, that can include pain or illness, whether or not it was committed in the presence of an officer, or it was caused or intended to cause reasonable fear of imminent serious physical injury or death. So maybe there wasn't an actual assault, but if the crime was committed because they wanted to create a fear that that might be something that comes about, again, that's where mandatory arrest is coming into play. So this is really the point when we talk about survivors having control over situations. Once 911 has been called, regardless of whether or not the survivor called 911 or neighbors called 911, at that point, the criminal process is very much out of the hands of the survivors. Once probable cause has been found, really it's up to the officers and then the U.S. Attorney's Office to determine whether or not they're going to move forward with that criminal case. Often the victim's wishes are not taken into consideration if they have enough evidence to move forward. And so when we talk to survivors, we want to make sure that they understand what the different implications are between filing a police report or a protection order process, because there's a lot more control that they have over the protection order process as compared to the criminal process. So when probable cause exists, the officers should be providing the victim with their names and their badge numbers. They should give them a police report number, and in DC that's called a CCN. They should also give them a domestic violence brochure, and they should be calling SAFE and referring them to the response line. It says if the victim consents, there are some areas in the city, so the higher call volume areas in the city are actually required, regardless of whether or not the client requests the services or says that they want the services, to call in all domestic violence cases. And that was really put into place because we wanted to ensure that if they disclosed in front of an officer that they didn't want these services, but if we call and offer our services ourselves, they may be more likely to take us up on those for a variety of reasons. And so some officers, some jurisdictions and some places in the city don't have to call every time, but some places do. So we're going to take a couple different trajectories. The first is going to be if the suspect is not present. So if the suspect is not present, as you can imagine, when people call 911, if you hear those sirens coming and you know that you did something that was a crime, a lot of suspects flee. A lot of abusers flee the scene. So if they show up, the police are still supposed to be taking a report. They should also be obtaining a description, and they should be canvassing the area to see if they can find the suspect. They should still prepare the police report and provide the victim with that CCN. You'll see CCN spelled out, Central Complaint Number. And then this last piece, they may arrest the individual on second sighting. So this is a policy or a protocol that's very specific to domestic violence cases. And basically what it means is that if the police leave, the suspect has fled, they're unable to find them, the police leave. The suspect comes back to the residence. That victim, that survivor, can call the police again, let them know that the respondent has returned, that the suspect has returned to the home. They can come back out, and they can arrest them then and there for that initial police report that was taken. Now, a couple of complications with second sighting arrests. There's no set time frame for how long that can happen. So it's really up to the individual officer as to whether or not they're going to make that second sighting arrest, depending on how long it's been since that initial police report was taken. We've had officers who have declined to make arrests for second sighting 48 hours after the police report was taken. And we've had other officers who have agreed to do a second sighting arrest up to 2 weeks after the initial police report was taken. So second sighting arrests are really great, but they're not guaranteed, and that's important to let the survivor know. So this is a flowchart for the Metropolitan Police Department investigative process. So again, remember, we're assuming that the respondent or the suspect has fled the scene. So we see 911 has been called and they've dispatched the police. The report has been made. There's probable cause that an inter-family offense has occurred. So again, those same relationship types that we talked about with the civil protection order process also hold true for the domestic violence process. So it's the exact same statute that constitutes domestic violence for both the civil and criminal processes. So the first thing is, if probable cause was not found, the police show up and they determine a crime did not exist. There was no crime that happened. A lot of times we hear this referred to as disturbing the peace or a family disturbance report. That's what we call it in the district. It's called a family disturbance report. They still have to document the incident, but there is no crime, so there's not going to be any prosecution from that type of a police report. And in the notes, you'll see it documented as an FD. That's family disturbance. So if they do decide that an inter-family offense has occurred, they're next going to see if the offender was present. If the offender is not present, you'll see that a detective is supposed to be assigned to the case and will contact the victim within 48 hours. So the only time a detective is going to be brought into a case is if either the offender fled the scene of the crime, or if a victim or a survivor filed a police report not on the scene. So they didn't file on the moment, they didn't call 911 in the moment, but they went to a police department later and they filed a police report. Those two incidences, that's when a detective is going to be assigned to the case. What's important to note is that detectives, like many other agencies in the city, are often overwhelmed as well. So they get about 34 new cases assigned each week. So it's important that if a survivor wants to move forward with the criminal process and has not spoken to a detective, that we try and link the survivor to that detective as quickly as possible. So the detective is going to be doing an investigation. They're going to be interviewing who they call the complaining witness or the victim. They're going to be getting statements. They're going to be collecting evidence. They're going to be interviewing other people who might have been present at the time. They're then going to see, did they believe an inter-family offense occurred? And if they have enough evidence, if they have enough material to move forward, they're going to take that information and they're going to present it for a request for a warrant with the U.S. Attorney's Office. Once that information has been submitted to the U.S. Attorney's Office, the detective's job is essentially done. And there are a couple of different things that can happen. So the U.S. Attorney's Office can approve a warrant request, or they can deny a warrant request. And if the warrant request is denied, that's really the end of the criminal process at that point. If an arrest warrant is approved, they're then going to have the judge sign off on that warrant, and they're going to send it back out to MPD for an arrest warrant. Now, an arrest warrant is different than what we talked about with bench warrants. Bench warrants, no one's actively looking for this person. With an arrest warrant, they are actively searching for the offender. And then at that point, we hope that the offender is arrested. All right? So now you see the other side of things. If the respondent is present at the scene, or the suspect is present at the scene, and the officers determine that yes, a crime has been committed, they will then arrest that offender on scene. So in both scenarios, whether there's a detective assigned to the case or the offender is present and is arrested on scene, the last point that really MPD is a part of this process is once that offender has been arrested. So there is a risk, because there is a mandatory arrest law, that sometimes officers can do what's called a dual arrest. So if they are unable to determine who they think is the predominant aggressor, so who they think is the person who is actually causing the threats or the harm, this is their policy for dual arrests. A dual arrest can only be made if both parties have committed an independent inter-family offense against each other, and one person was not acting in self-defense, and a sergeant, a detective, or another senior official has been called to the scene to make the determination. So an officer who responds, that initial officer, they should not be making dual arrests without consulting a senior official. So in terms of mutual combat, and a lot of what we get is conversations from participants, from MPD officers, about mutual combat, where there's not really one person who is the dominant person, who is the main offender. So what percentage of domestic violence cases do you believe are mutual combat? The answer is that it's only about 3%. And this is according to the Justice Department and of the International Association of Chiefs of Police. So dual arrests should not be happening in domestic violence cases that frequently. And that's important when we talk to officers and when we teach them how to do assessments to determine who the predominant aggressor is. So if both parties have injuries, they are required to determine who the predominant aggressor is and only arrest that person. So we're going to have Sergeant Parson come next week, and he's going to talk about what process they go through to determine who they believe the predominant aggressor is. So you see the quote at the top, call us if he comes back or if he actually hits you. There should be a report taken for every time the police come to a complainant's home and take a police report or come and respond to an allegation of a crime, regardless of the outcome of the case. So whether it's a family disturbance report, a simple assault report, physical assaults are not the only actions where someone can be arrested. You can be arrested for threats to do physical harm. You can be arrested for destruction of property. There's a variety of arrestable offenses in domestic violence. So officers should be responding appropriately to all types of domestic violence. Now, if an officer cannot find probable cause, again, they can document this, and they should still be documenting it with a family disturbance report. But that family disturbance report is not a report documenting a crime. It's just documenting a complaint. So when we talk with officers about doing a predominant aggressor analysis, things that they should be considering are the intent of the law, which is to protect victims of crime. They should be looking at the nature and the extent of the injuries. So are some injuries, do they appear to be surface level injuries? How does the story match up to the injuries that are being presented? They should be taking into consideration threatening statements made by one party. They should be taking into consideration protection orders, the relative size and strength of each party, whether and how weapons were used, prior histories of assault, and possible use of self-defense by one party. So when we train officers, we talk with them about how it can be true, where sometimes the only person who's presenting with any physical injuries that you can see is the person who we would identify as a predominant aggressor. And so walking them through how that can be true and making sure that they can match up the narratives of each of the parties to the injuries that are present is really important for them when they're doing that analysis. So after the arrest is made, we're going to focus on misdemeanors because that's the vast majority of the cases that we hear are misdemeanor cases. Felonies are a lot more complicated, and then the U.S. Attorney's Office has victims advocates, and they're automatically assigned to felony cases. So most of the cases that we're walking clients through are going to be misdemeanor cases. So if an arrest is made on scene, the suspect's going to be taken for booking at the district station and then transported to lockup at the court. They might be locked up at the district station if either there's not enough space at the court or if it's too late in the night and they can't transport them for whatever reason. But that's one of the reasons why the court is 24 hours is because overnight lockup is in the courthouse. So property is taken from them and recorded and kept at the district. And so this is something, when we're safety planning, it can be difficult or problematic if the suspect is arrested with copies of the victim's property, like house keys, because the district is going to hold them until that person is released, hold that property. The U.S. Attorney's Office at that point, once an arrest has been made, the U.S. Attorney's Office is then the agency that is making the decision as to whether or not to charge the suspect with a crime. We refer to this as papering. So if they choose to paper the case, they are going to be prosecuting the case. If they are not going to be prosecuting the case, we call that no papering the case. And the U.S. Attorney's Office, they start making those decisions when the arresting officer presents the suspect and the case to them. So in the mornings, the officers who made the arrest have to come to the courthouse and present the information to the U.S. Attorney's Office. And they can start making those decisions very early in the morning. The U.S. Attorney's Office does have a policy that they try to call the complaining witness to see if they want to cooperate with the case. Now, the U.S. Attorney's Office is typically only going to call them one time. So if there's not enough evidence to move forward and the case is contingent on the assistance from that person who the crime was committed against, and they don't answer the call from the U.S. Attorney's Office, they may not choose to prosecute that case. So when we're talking to survivors about whether or not they want to pursue charges, if they do, they need to be aware to look out for a phone call from the U.S. Attorney's Office the morning after the suspect was arrested. And arraignments in DC happen every day with the exception of Sundays and federal holidays. So if someone is arrested on a Friday night, they may very well be arraigned and released on Saturday. So generally, unless suspects have long criminal histories, long recent criminal histories, they're probably not going to be held much longer than 24 hours. And that's really important when we're talking about safety planning. So if the case is no papered, if they decide they're not going to prosecute the case, they don't have enough evidence to move forward, they feel like they can't win the case, then they can decline to charge the suspect with the crime. The suspect is then given a letter showing that the case was not papered, and then they're free to leave. And that's it. So on the day of arraignment, people who are no papered, people who there's not going to be a case against them, could be let out of jail as early as 10 a.m. And about half of all arrests in DC for domestic violence are no papered, meaning there's not going to be criminal prosecution for them. So the next question is, what is victimless prosecution? Victimless prosecution occurs when the case is going to be papered. So, as I mentioned earlier, the suspect is going to be arraigned in court that day. The U.S. Attorney's Office is going to call that victim to see if they want to cooperate. However, the U.S. Attorney's Office can choose to move forward with the crimes whether or not that complainant is going to willingly assist with the case. And that's what victimless prosecution is. The person who's the victim of the crime does not have to participate for the government to continue to charge them with that crime. So at arraignment, that's when the suspect is going to be arraigned in the courtroom. They're going to be read the charges that they are accused of committing. If the case is going to be papered, most of the time, that person is going to be released that same day. But there are going to be what are called release conditions, things that they have to abide by to stay released. And the first and the most common was a no contact order, or what we call a criminal stay away order. And you'll see that written out as CSAO. That can be requested by the U.S. Attorney's Office, and typically it orders the defendant to stay away from the victim, any witnesses to the crime, and the location where the crime happened. So it is somewhat of an ad hoc protective order, but it's only specific to those things. It's only specific to the things that are important to the prosecutor of the case. It doesn't include child custody. It doesn't include vacating people from shared residences. There are a lot of things that it does not include, but it can be very helpful for people, especially over the weekends when they can't come to court to get a protection order. They're also going to determine the status of the defendant and whether or not they're going to hold them for any period of time. So they're going to look to see if they have any open cases with probation or parole, other criminal cases, and they'll make a determination if they're going to hold them for any period beyond that initial 12 to 24 hours after arrest. But most misdemeanors are released on personal recognizance, and they sign the criminal stay-away order. They'll also have to check in with pretrial services as the case continues. So they will be under some supervision from pretrial services, but it's not quite as intense as folks who have probation or parole through CSOSA. So at arraignment, they enter a plea. If they cannot afford an attorney, there is an attorney assigned to them. They're given their terms of release. They should sign the no contact order, and they sign to acknowledge that they know when their next court date is. Defendants can be held at trial, but typically they're going to look to see if there were any previous convictions for the same crime against the same person, or if they're believed to be an imminent risk to public safety, or if the person is severely mentally ill and requires hospitalization in a mental health facility, and they'll need to be evaluated at that facility. So the U.S. Attorney's Office may ask for a hold, but judges often deny those requests. So a criminal stay-away order, we've talked about briefly, it's requested by the U.S. Attorney's Office, not by the victim. So it's not that the victim wants the safety, it's that the prosecutor, which is the U.S. Attorney's Office, wants to protect their case. This order lasts until the end of the criminal case, but the victim can request that it's lifted sooner. But that decision ultimately rests with the U.S. Attorney's Office and with the court. It is pretty vague if you see it. I'll show you an example of one next week. It only lists the names and the addresses that the defendant must stay away from. So again, there are very limited protections in the criminal stay-away order. The other thing is, once the case is not being pursued any longer, that criminal stay-away order goes away. So if at the first status hearing they determine they don't have enough evidence to move forward, then that criminal stay-away order is gone. So we're going to pick up where we left off with the flowchart. So once the offender was arrested, will the case be papered? If it's not, then the offender is going to be released without any conditions. If it is going to be papered, the next decision is, will the offender be held? They may be held, and the date could be anywhere from 72 hours later to until the next status hearing. It really varies case to case. If the offender is not going to be held, they're going to be released Monday through Saturday. That's when arraignments are typically happening. And there will be some type of release conditions, and generally that includes the criminal stay-away order. Status hearings generally happen about 2 weeks after the initial arraignment. And that's when the judge, the U.S. Attorney's Office, and the defense attorney decide if there's going to be a plea offer or a trial date set and when that's going to be. The victim can attend, but they do not have to be present. And this is really where our work in terms of the immediate crisis intervention work ends. So I'm not going to go any further in terms of the criminal process because we typically are not following cases all the way through. At that point, we're going to hand them off to a longer-term case management organization. And most of the initial pieces where there are points of their joints where things can change really happen in the first few weeks of these criminal cases. And so for us, that's the most important part, and that's what we need to be really well versed in when we're working with survivors. So the next thing we're going to talk about is crime victims' compensation. Crime victims' compensation, what it is, it's a pot of money that's allocated to victims of crime in D.C. And that's what funds a lot of the services that survivors are eligible for in the city. And that includes everything from emergency housing. So they fund up to $3,000 for emergency housing, and that can be through one of the housing programs like Safe Space Shelter, or they can self-pay for a motel and get reimbursed. It also includes about $1,500 for what's called relocation assistance. So that can be used for a storage unit or a moving truck or a deposit first month's rent. It can also include up to $25,000 in money for medical-related expenses to the crime. They do have to go through their insurance first, but it's very helpful for folks who have copays, especially if they're injuries that have a lot of medical needs. There are often a lot of copays that go along with that. And it can also pay for counseling services if you have a private counselor that you prefer to go to. It can pay the copays for those counseling sessions. There are a lot of really great things that crime victims compensation can pay for, and services that you can't really find in other ways in the city. The big thing for us to note is that to be crime victims compensation eligible, you have to have one of three types of documents. You either need to have a temporary or civil protection order, a SANE exam, so a sexual assault nurse examiner exam, often referred to as a rape kit, or a police report for a crime. And this is why it's really important for us to know what type of police report is taken, whether it's a family disturbance or another type of police report, because if it's a family disturbance report, that's not going to be crime victims compensation eligible. So to get crime victims compensation and other remedies, they have to apply in person. There are some exceptions if people have limited mobility and they can't get to the crime victims compensation buildings. They can deploy advocates out, but that's really in cases where the person cannot leave where they are staying. They will need eligibility documents, so they'll need a physical copy of that police report, a copy of that protection order, or a receipt from their SANE exam. And they may request a referral. So SAFE can provide a referral via email. Occasionally, though, if the documentation that they're using is a police report, they may request a police referral, which we can assist them in getting. So they'll have to get the initial officer who took the report to send a referral on their behalf. In crime victims compensation, it is located just a couple of blocks north of the courthouse at 515 Fifth Street. There's also crime victims compensation co-located in the Southeast Domestic Violence Intake Center. So when folks go to the Southeast office, they can meet with crime victims compensation in that same building, in that same office space. And that's the end of the criminal presentation. If you haven't already, fill out your review sheet and we will review it when we come back to class next week. Thanks so much.